keep one theme in front of us this entire time. It's that in North Dakota, especially in prairie pothole country, the federal Clean Water Act question is only one lane. You'll hear today that the WOTUS spheres look narrower after a recent Supreme Court decision that's referred to as the Sackett decision. But keep in mind that USDA wetland compliance, water resource district, land use controls, U.S. Fish and Wildlife Service easements, and concerns about neighbor impacts or downstream impacts can still be front and center, even if we've addressed the WOTUS concern. So we're going to start today with talking about why WOTUS matters on a working farm or ranch. When people hear WOTUS, they often think this is just another Washington policy to fight. But on the farm, it's a much more concrete problem than that. Let's start out by just saying WOTUS is the threshold question that helps decide when federal Clean Water Act permitting becomes part of what otherwise feels like something that should be just a local land use decision. So if a feature on your land is federally jurisdictional, then any work in that feature involving dredged or fill material can trigger Section 404 of the Clean Water Act and the association of issues that comes with that. What that can mean is you might need permits. This might cause delay to your project. It might cause you to engage and invest in engineering to do mitigation of the project impacts, some paperwork. In some cases, it might mean the project just simply cannot proceed in the way that you want it to or in the way that was first planned. If the feature on your land is not federally jurisdictional, that does not automatically mean the project is problem-free, but it does usually mean that one major federal layer is reduced or removed from our analysis. So for producers, this comes up in some real world situations. Those can be like cleaning or reshaping a drainage ditch on your farm, adding or replacing culverts to public or private roadways or crossings, moving spoils, putting in tile, building a crossing, shaping a levee, or improving access roads. Those are just a small sample of the type of projects that could trigger this question of federal Clean Water Act jurisdiction. And for those on the webinar or listening on the recording that are enrolled in USDA programs, that same project can raise a separate swamp buster question even when no federal permit is needed. So what I mean is, even if we have determined and done our analysis or proven that WOTUS and the Clean Water Act do not apply, that does not mean that you don't have regulation under swamp buster or some other federal law. It just means we're not dealing with the Clean Water Act in that example. So the right question is not just, is there water here? The right question is, what kind of feature is this under the rules that apply in North Dakota today? And what kind of work am I planning to do to it? So with that, I want to move on to talking about the legal frame for WOTUS. Here's the simplest legal frame in the simplest terms that I know how to give. There are really three questions that should be asked. First, you want to ask, is the feature a water of the United States? Second, you want to ask, is the work I want to do the kind of discharge or activity that the Clean Water Act regulates? Third, you want to ask, even if those first two boxes are checked, is there an exemption that applies, such as an ongoing farming activity or maintenance of an existing draining ditch? If the answer to the first question is no, then you're often out of the federal Section 404 lane. If the answer to the first question is yes, and your work involves dredged or fill material, then you may be in permit territory unless you can show that one of the exemptions in the Clean Water Act applies. And if the situation is uncertain, which is the most common situation we find ourselves in, then there is one practical tool that's called an approved jurisdictional determination, or we'll often shorten it in this presentation to an AJD that you can apply for and get from the Army Corps of Engineers. Those approved jurisdictional determinations, or AJDs, are valid for 5 years, meaning you can rely on them for 5 years. And Amanda, I just want to pause. There's a chat that asks if there's an audio problem. So are you still able to hear me? Maybe we can get confirmation that folks that are listening in can hear me okay.
I can hear you.
Okay.
So
I'll keep going and just maybe ask an audience member to type in the chat to confirm that they can hear me okay. So as I said, those AJDs are valid for 5 years. It also matters that producers are often dealing with more than one legal lane at the same time. So as I mentioned, Section 404, this is the dredge and fill lane. But under the Clean Water Act, Section 402 can also involve actual discharges from a point source. And then, as I mentioned, USDA wetland compliance is its own lane that's tied to your USDA farm program and federally subsidized crop insurance eligibility. So, one smart discipline is to stop treating all water law as one bucket. It is usually two or three different questions riding together in the same project. And this is why people often tell me, "Wow, you know a lot about one thing." I like to say my practice is, a mile deep and an inch wide, because when it comes to water law, there are so many different layers that apply. So let's talk next about why the definition has been so controversial. The reason this debate never seems to stay settled is that it sits right at the fault line between federal power and what we call state or local control over both land and water. One side says the federal government needs enough reach to protect downstream waters and wetlands. The other side says federal regulators have repeatedly pushed past what Congress actually authorized, especially on things that are ordinary land management decisions in agriculture. So that tension has played out in a long chain of court cases and also rule changes. The Rapanos case in 2006 left the country with competing tests. That's because the Supreme Court couldn't agree on what the test should be for whether something is waters of the United States or not. But out of that court case in 2006, the most influential test looked broadly at waters and wetlands that had a significant nexus to navigable waters. That test allowed for the broadest interpretation and pull of land into what could be considered waters of the United States. The 2015 rule that came after that tried to broaden even further the federal reach into waters of the United States, and then also attempted to clarify what it meant for a water to have a significant nexus to other navigable waters. Then in 2020, the Navigable Waters Protection Rule went the other direction and tried to narrow that jurisdiction. But through court litigation, that rule was vacated in 2021. Then the 2023 rule came out, and then the Supreme Court weighed in again in the Sackett decision in 2023 when it flatly rejected the significant nexus approach that was adopted by the court in 2006. After that, the agencies had to conform their rule and then kept operating under a patchwork because of various litigation and injunctions. So when you ask the question, why does the answer on WOTUS keep changing? The honest answer is because the answer really has changed. Sometimes that's through federal rulemaking, sometimes that's through the Supreme Court, sometimes that's through lower court injunctions, and sometimes the answer at any given moment differs depending on what state you're standing in. So are you frustrated? Yeah, that's fair, but it's actually the history of this issue and hopefully explains why it's a complex question, and knowing what the current rule is in your current state is key. So let's dive into Sackett, which is the big case that I think folks have recently heard about and are probably asking, what is this case about? And you've probably heard that the Sackett case really helped this question, and I want to explain where that's true and where that's not. So if you only remember one legal turning point in my presentation today, I think this is the case. Remember the Sackett case. The Supreme Court in this case made two really big moves. First, it said that the Clean Water Act covers only those relatively permanent, standing, or continuously flowing bodies of water that are described in ordinary language as streams, oceans, rivers, and lakes. Second, it said that wetlands are only covered when they have a continuous surface connection to one of those covered waters that I just mentioned, so that there is no clear line between when one of those covered waters, one of those streams, oceans, rivers, and lakes ends and where the wetland starts. Just as important as those two holdings, the court flatly rejected the significant nexus test. That matters because under that test, for years, the agencies were relying on the idea that if a wetland or water feature had a significant effect on downstream water quality, then that could support the agencies claiming jurisdiction over that wetland or water feature. Sackett said that is not the right test under the statute. Whether it should be under the Clean Water Act is a different debate for Congress, but the court said as Congress drafted the Clean Water Act, significant nexus test doesn't apply. So at the farm level, that means that many isolated wetlands and many non-permanent features become harder for the agencies to regulate under federal law. But I would encourage you not to overread Sackett. It didn't erase federal jurisdiction. Relatively permanent tributaries still matter, and directly abutting wetlands do still matter. Connected ponds and lakes can still matter, but what has changed is that the connection has to be much more concrete than just an argument that there's some broad ecological relationship between that abutting wetland and the downstream waters. So let's dive into where things stand right now in 2026. Here's the current status as of today. The amended rule from 2023 still remains the regulatory text where it was not enjoined or stopped by the courts. And that's because of ongoing litigation between the regulated community and the federal government over the WOTUS question. So because of this litigation, the EPA and the Army Corps are applying that amended 2023 rule in 24 states, the District of Columbia, and the territories, while also still applying the pre-2015 regime, which was constrained by the Sackett case in the other 26 states. And North Dakota is in that second group. It's one of the states that's involved in the litigation. And so because of that, it's applying the 2015 rule, the rule that's now a regime, I should say, not rule, that has been around for 11 years, but modified slightly by what the court said can stand and can't stand out of that Sackett case. So at the same time, the agencies have not stopped moving. In March of last year, they issued some national guidance around what it means to have a continuous surface connection. And in November of last year, they announced a proposed new WOTUS rule. That proposal was published in the Federal Register. If you want to search for it, you can find it by looking at the Federal Register from November 20th, 2025. The comment period on that proposed rule closed on January 5th of this year. So that proposal is not final yet. So what does that all mean? Well, the settled part is this. The Sackett case, that case governs nationwide. Here's the unsettled part. There's still not one single stable national definition for waters of the United States. For North Dakota producers, the practical takeaway is that today's answer is narrower than the 2023 rule's broader language, but the agencies are still actively trying to clarify terms like what is a ditch, what is relatively permanent water, how does groundwater interplay, what does it mean to have a continuous surface connection. And this is why we're going to talk today about how important documentation and especially early screening or early coordination with the agency matters so much to your project. So on the next slide, I want to get into, in plain English, what applies in North Dakota today. Here's what applies. It's the pre-2015 regulatory framework limited by the Supreme Court's Sackett decision. And this again is because North Dakota remains in the injunction group from the litigation challenge to that January 2023 rule. That means that the agencies in North Dakota are not using the old significant nexus approach. From a regulatory certainty standpoint, that should be good news to folks on the webinar or listening to this recording. So the practical question is whether the feature is a relatively permanent covered water or whether the feature is a wetland with some kind of continuous surface connection that Sackett requires. For producers, that is a narrower than that's a narrower decision than many people feared a few years ago when we were considering whether or not the Clean Water Act applied to our project and whether or not we were going to have to engage with the Army Corps before moving forward. But again, it is not a free pass to assume that every prairie, pothole, or wetland area is outside of federal jurisdiction. So here's my best practice message on this slide. If your project is close to a wetland or a creek or a draw or a ditch that has a natural tributary feel, and if your work involves some kind of fill or excavation or moving dirt around, do not just guess from your cab or machine. Get the Corps involved early enough that you can adjust your plan before you sink any money into making the wrong assumptions. Then keep the USDA and the state drainage law questions on a separate list because those do not disappear even if the federal jurisdiction call looks narrower or has been satisfied. So I want to give some examples now on farmland water features that are most likely, least likely, and then a kind of a gray zone area to give you some examples of how to think through screening whether or not you should be raising a flag about Clean Water Act jurisdiction. Again, this slide is meant to be a screening tool, kind of a check on should we be thinking about this, not an official legal determination. But we're going to start with features that are more likely to be federally regulated. These are your relatively permanent creeks, streams, rivers, and lakes, tributaries that are standing or continuously flowing and connected into that kind of system, and then wetlands that are directly abutting those covered waters. Now let's look at features that are less likely to be WOTUS under the current North Dakota framework. These would be ditches that are dug entirely in dry land, groundwater, or water moving through subsurface tile, and many isolated, that's the keyword, isolated prairie potholes after the SACA decision. The 2025 proposal from the agency would make some of those exclusions even clearer, especially around ditches that are excavated entirely in dry land and groundwater drained through tile systems. But again, that proposal is not yet final. So we'll be watching the final rule and then hopefully getting out some guidance to folks to help them understand what from this presentation changed out of that final rule, if anything. The gray zone is where most of our issues, of course, lie. Although the gray zone, as I said, is getting narrower after SACIT, but it is still there. So these questions that come up are, was the ditch really dug in dry land? Or does it occupy what is functionally a tributary or a wetland? Is the flow relatively permanent or is the flow only occasional? Is the work we're doing true maintenance of an existing feature or are we deepening, relocating, or expanding the feature on the ground? And even if the answer, again, is no federal jurisdiction, does USDA still view the area as a certified wetland or a wetland affected by the work that we're doing? Those are the questions that can move a project from something that's easy to something that can get complicated and expensive. So now I want to go into what I'm calling like the producer playbook on drainage, tiling, and ditch maintenance. I think this is the slide that probably many people came to the webinar for. There are real exemptions in Section 404 of the Clean Water Act for established farming, ranching, and minor drainage, and for maintenance, so not construction, but maintenance of drainage ditches. EPA still says those exemptions matter, but there are two mistakes that I see producers sometimes make. The first is assuming that every drainage-related activity counts as maintenance, and the second is ignoring what's called the recapture problem, where you have an exempt activity, but it loses its exemption if the work brings an area into a new use and reduces the reach or impairs the flow or circulation of regulated waters. So maybe it's easier to talk about what is usually on firmer ground. Cleaning an existing man-made field ditch in the same footprint without expanding it and with good records showing it is truly maintenance. That's the least risky. What is riskier? Well, that would be new ditch construction, relocating a channel, side casting the spoil piles into an adjacent wetland or wet ground area, deepening a feature that may actually historically be a natural tributary, or using the word maintenance for a project that really is expanded drainage into previously unfarmed wet land. Those are issues that can all trigger WOTUS, Clean Water Act, permitting. And I think tile itself really deserves its own sentence here. So the tile line itself is not automatically a Section 404 permit event, but if the tile outlet, the related ditch work, the fill that is associated with installing that tile, trench spoils, or any wetland conversion takes place, all of that can matter and be very important to the federal jurisdiction question. And in prairie pothole country, the real danger is often not the trench itself, but it's the hydrologic effect on nearby wetlands and the separate USDA consequence of that change. So let's talk a little bit about the 2025 rule, because this is supposed to be a WOTUS update, and that is the latest rule. And let's talk about what the proposed rule would change for agriculture. So the agency's November 2025 proposal is really worth watching, I think, because it gives us the clearest signal about where the policy on this question may move next, especially for agriculture. The proposal would define ditch and broaden the ditch exclusion for features that are constructed or excavated entirely in dry land, which again, for the regulated community is good news. It also clarifies and adds an explicit groundwater exclusion that includes groundwater drained through subsurface tile systems. When we talk about drainage law in North Dakota and we use the word groundwater, we're usually not referring to the water below the surface that is drained through drain tile. We're usually referring to the water that is pulled out of the aquifer for an irrigator pivot or a well. But when it comes to Federal Clean Water Act jurisdiction, there is little less clarity than what I see in North Dakota state law on the definition of groundwater. And the 2025 rule really tries to clarify that and say that regulation of groundwater is not the water that is commonly drained through drain tile that's below the surface. That's something different that's much further into the ground, typically coming out of the aquifer. Also, the rule would try to define terms like relatively permanent and continuous surface connection directly in the rule text to add some clarity to what the Supreme Court meant when it used those terms in the second decision. So for producers, if those changes are finalized, they could reduce uncertainty around some agricultural ditches and tile drainage systems, which again is the good news side. The caution side is that the agencies would still look hard at whether the ditch really was dug in dry land or whether it sits in what is in substance a tributary or a wetland. So the record facts and data will still continue to matter and be important. Here's my advice for the next 3 years. Don't make your business plans around the assumption that this proposal from 2025 is going to solve everything. It is likely to narrow uncertainty around dry land ditches and tile, but again, any final rule is likely to draw litigation too. So that means that some clarity may improve, but there's still total uncertainty likely, and that's likely to come out of the litigation as an issue of this importance is almost always litigated by both sides of the regulated community. Next, I want to talk about why the Prairie Pothole region, which covers most of North Dakota, is so unique in this regard. And it's because the landscape itself does not look like the kind of neat stream and river systems that fits easily into bright legal categories, which are often what regulators are drafting for. If you don't know this already, prairie potholes are depressional wetlands that were created by glaciers. They fill with snowmelt and rain, and some are temporary, while others are much more lasting. In the upper Midwest, prairie pothole areas are also one of the most important wetland regions in the world and support more than half of North America's migratory waterfall, which is why it would be not wise to assume that this is just a North Dakota issue. What happens in the prairie pothole region is really watched and monitored closely by the entire country. And it's that ecological importance why the legal line drawing here was really hard after Sackett. Many of these basins that are trying to be regulated are seasonal. Many do not have an obvious surface connection to relatively permanent streams or rivers, but they do matter a great deal ecologically. However, the legal test after Sackett is not simply ecological importance as the way it used to be prior to that decision in 2023. It is now clearly whether the feature fits the statute as the court now reads it. So when you feel like the landscape in North Dakota doesn't fit these categories cleanly, that feeling is right, and that can be appreciated. That is part of what makes this region different from a place where jurisdictional questions mostly run through obvious stream channels. That might be just a lot of words to say the challenge of applying the WOTUS rules and the Clean Water Act jurisdiction is really a uniquely harder challenge in this part of the country than it is around the rest of the United States. I want to make sure we're clear on the next slide as to why tile drainage is especially sensitive in pothole country. Tile drainage is especially sensitive here because of the hydrologic effect that can extend well beyond the line of the tile itself. NRCS guidance for the Prairie Pothole region emphasizes lateral effects, meaning a drainage project can draw water horizontally through the soil and change wetland hydrology some distance away from the trench. The agency even maintains a lateral effect database and regional guidance specifically for projects in Iowa, Minnesota, North Dakota, and South Dakota. This matters because a producer can have a project that does not look like a federal WOTUS permitting problem, yet still creates a serious USDA wetland conversion issue. In other words, your tile project can be legally narrower under SACIT on the federal jurisdiction side, but still be legally dangerous under the USDA program rules. So when we're planning a drainage project, we have to understand and apply both sets of rules and understand where they're similar and where they're different. Here's the practical lesson in all this. Do not treat your tile trench as the whole footprint of the decision. Think in terms of the wetland system that may be influenced around it, including potholes, wet spots, soil indicators, certified wetlands, and like I said before, downstream or neighboring effects. So on this slide on your screen, we're going to talk about how WOTUS aligns with and conflicts with USDA conservation rules more specifically. And this may be the single most important slide in this presentation for avoiding bad assumptions. Clean Water Act WOTUS and USDA wetland compliance overlap, but they are not the same question, and they do not have the same consequence. Under the Clean Water Act, the trigger is federal jurisdiction plus a regulated discharge. But under USDA wetland compliance, the trigger is whether a wetland has been converted or farmed in a way that affects program eligibility. NRCS certified wetland determinations and the hydrologic effects of drainage matter a great deal here on the USDA side. What this means is that your project can escape federal WOTUS jurisdiction after SACIT, but still create a swamp buster problem because tile, grading, fill, clearing, or excavation has changed the wetland hydrology on your landscape. USDA materials with guidance on this point are pretty blunt. Before tiling farm ground, the only way to have certainty is to check with NRCS to make sure you are not draining a protected wetland, because loss of USDA benefits and after 2014, loss of the federal subsidized crop insurance can be a real consequence for most producers today. So here's the phrase I want everybody to remember. No federal Clean Water Act permit needed does not mean no USDA problem. They're both federal agencies, but they both regulate similar things in a different way. They are different doors, and a project can walk through one while still running into the other. I don't think the presentation would be complete if I didn't mention on the next slide other places where WOTUS comes up on the farm or ranch. Drainage clearly gets the most attention, especially from me. I'm a ditch lawyer. I'm a drainage lawyer. It's where I focus my practice for farmers and ranchers. But there are folks on this webinar or listening to the recording who recognize that WOTUS questions come up in a much wider set of projects than what I've talked about so far. Installing or enlarging culverts, building stream crossings, shaping berms or levees, building access roads through wet ground, relocating or straightening a draw, dredging or cleaning a pond where natural waters are involved, placing fill for erosion control or flood repair can all raise similar questions, even if the goal or the intent has nothing to do with draining or reclaiming wet ground to improve cropland. There's also the wastewater side. Even if a ditch is not jurisdictional for one purpose, an actual discharge from a discernible conveyance into a regulated water can create a separate issue under a different Clean Water Act lane. So producers should resist the temptation to think this topic only belongs to those who are engaged in drainage or to their drainage contractors. If the project moves dirt, changes hydrology, touches a natural water feature, creates a discharge path, then run it through a quick federal USDA and state screening process before the work starts to figure out which laws, which jurisdictions am I triggering here. On the next slide, I want to give you a practical compliance checklist before you start your work. So here's the practical checklist that I would hand a producer who says, I don't know where federal jurisdiction begins or where it ends, but I need to get this project moving. Keep this checklist in mind, visit it, and think about it early in your project. Step one, you want to map the feature. Mark the ditch, the tile outlet, the wet spots, the potholes, adjacent low ground, and any natural channel on recent aerial photography. The more you can get everyone looking at the same picture, the better. So this is really about knowing what is on your landscape and what might be affected by the project you're considering. Step two, you got to separate the legal lanes. To do this, I think you have to ask yourself three primary questions. Number one, do I have a Clean Water Act permit issue? This one takes the longest to solve, so I would think about this one first. While you're thinking about that, you can be thinking about, do I have a USDA wetland compliance issue? And then number three, do I have a county or state drainage law issue? Step three, get your USDA paperwork early. If drainage, fill, clearing, grading, or excavation is involved, update your AD 1026 with the USDA and confirm whether there is a certified wetland determination already in place. The USDA and NRCS put real weight on that early paperwork, but also the determination from the NRCS about whether there are wetlands on the property or in the vicinity of your project can also help or hurt satisfying your question on whether or not a Clean Water Act permit is needed. So having a certified wetland determination that is up to date and is clean and correct can really be an important and first early tool in addressing the Clean Water Act problem. Step four is if filler excavation is near water, contact the Corps early enough so that you can change your design or change your approach if needed. And then step five, if you're calling the work maintenance, document maintenance like you mean it. Photos, historic alignment, dimensions, old map, prior ditch footprint, anything you can compile and keep as a record showing that you are keeping an existing system going rather than expanding it. Early paper and photo discipline is usually far cheaper than cleaning up a bad situation later. This is another way of saying once the work is done, it's not impossible, but it is harder to prove what was there on the landscape before you did the work. So on the next slide, let's go through three common scenarios that come up for North Dakota producers. First, I'm going to call this the green light example. So green light meaning this is where you would have the least amount of concern. A green light example is cleaning an existing man-made field ditch in the same footprint without widening or deepening it beyond maintenance, without pushing spoil into adjacent wet ground, and with records showing it has been maintained that way before. That's the kind of project where a Section 404 exemption may apply well, though you still screen county and state drainage rules. Second, the yellow light example. This is where you may be okay, but should be applying some caution and make sure you're understanding what is triggered and what is not. This example would be installing tile in cropland near potholes or persistent wet ground. And this is exactly where most people misread the law if they look only at federal jurisdiction. Maybe there is no federal WOTUS permit issue here. Maybe there is. But either way, a USDA wetland determination, an analysis of the setback effect from your tile, and neighbor drainage issues and local water resource district permitting laws are still critical. So this is a classic situation where the federal answer may be narrow, but there's still a practical risk profile here that you need to think through in terms of USDA considerations and then local and state drainage laws. Third, this is the red light example. This is where you should exercise the most caution. Deepening or relocating a ditch that may actually occupy a natural tributary, placing spoils from that work in adjacent ground that's wet. That is not a project where I would trust the label maintenance. That's not what the definition of maintenance means. That's a project that can raise Section 404 permit questions, can also raise USDA questions and state drainage questions all in one project. So the broader lesson from these examples is not that you need to memorize this doctrine, but you just need to understand and have a reliable screening instinct for when you need to slow down and get review and when you've got the green light and you can proceed at the same speed through with your project. Next, I want to talk about what producers can expect over the next 3 years. So again, this is just my outlook over the 3 years. I have been doing drainage law and water law my entire career, which now has been 14 years. And I would say this and U.S. Fish and Wildlife Service easements are probably one of the two most major areas where the law is constantly changing and the agency has been most difficult to deal with. Although in drainage law, I'd say USDA wetland compliance and state laws have also changed many times in the last 14 years. These are the two agencies, the Army Corps and EPA under the Clean Water Act, and Fish and Wildlife Service for waterfowl production area easements, where it can be hard to get to the most predictability. So these are just my predictions for the next 3 years, but this could easily change with litigation or new administrations. What I think we'll see is some narrowing and some clarification coming out of a final rule from the one that was proposed in 2025, but we are also certainly going to see continued litigation over that rule. So the agency's 2025 proposed rule squarely targets ditches, groundwater, tile drainage in key jurisdictional terms in a way that I think creates more certainty for our North Dakota producers. So I do expect some additional clarity in those areas, whether through a final rule or some agency guidance or both. But as I said, I also expect continued legal challenges and possibly continued geographic differences depending on how the litigation develops, meaning we could see different rules apply for Prairie Pothole region than what might apply for the rest of the country. I think that historic aerial imagery, your drainage record maps, soils information, and site-specific records are going to become even more important in those close call situations. So like those yellow light examples and those red light examples. And I expect the practical split between federal WOTUS and USDA wetland compliance to become more, not less important in prairie pothole country. In those 14 years, I think the regulatory framework today surrounding USDA wetland compliance is the best that I've seen it in 14 years. And I point that out to say that in light of the uncertainty going on with the Clean Water Act and WOTUS, in my opinion, now is a good time to understand whether or not your USDA wetland determinations are certified and to look at those certified maps and understand whether or not those maps are correct. And if they're not correct, to take advantage of a current climate right now that's very supportive of getting those maps corrected and updated. Because a very accurate and updated NRCS certified wetland determination map will be, in my opinion, a very important, if not the most important tool to advocate for your farm and your operation under the Clean Water Act and under Fish and Wildlife Service easements in the next 3 years. So the best operating posture is probably being a little conservative before earth moving, aggressive about your documentation, and just to be realistic that WOTUS certainty is still a moving target rather than a finished chapter. And on my last slide, I want to just give producers some takeaways, and then we'll move into opening it up to question and answer for as long as Amanda will allow us. But here's the 5 takeaways that I want to leave you with in today's presentation. First, it's to understand that North Dakota is currently operating under the pre-2015 regulatory regime, but as constrained by the Sackett decision. We are not in North Dakota operating under the 2023 rule text that applies in some other states. And again, that's because North Dakota is engaged in litigation. Second, the takeaway is that drainage, tiling, and ditch maintenance are where WOTUS most often shows up for producers. But the hardest call is usually what the feature is, not what machine is on it. Third, after Sackett, many isolated prairie potholes are less likely to be federally jurisdictional under the Clean Water Act. But for those that are not covered under the Clean Water Act, USDA wetland rules still matter a great deal. Fourth, it's that there are some real exemptions here, like maintenance exemptions, but keep in mind that going beyond maintenance, so doing expansion, relocating a ditch, or converting wetlands into cropland should not be relabeled as maintenance. Those are the things that are typically going to trigger something that's going to kick us out of that safety net of the maintenance exemption. Fifth, for projects where you're uncertain, update your AD 1026. This is the enrollment form or the self-certification with USDA, which if you mark yes that you plan to do new drainage work, will trigger a review by NRCS as to whether your wetlands are certified and whether the work you're proposing to do will convert a wetland in violation of Swamp Buster. So for those uncertain projects, file your AD 1026 early, confirm that you have a wetland determination and that it meets the current standards for a wetland determination that is certified. That changed as recent as 2024. So make sure you understand what it means to have a certified determination. And then call the Corps early before you move dirt to try to get clarity on where you need further engagement with the Corps or whether the Corps, hopefully in a best case scenario, can tell you early, no, this is not an area where we're concerned about jurisdiction. So here's the practical center of gravity for this presentation. The law is still moving, but you don't need to feel helpless here while it moves. If you follow this discipline screening process, you obtain and do your research to get good records and maintain good records, and you have early contact with the right agencies, and you keep in your mind that there's a clear separation here between Federal Clean Water Act and Federal USDA questions, you're off to a good start. You can prevent a lot of unnecessary trouble and hopefully delay or streamline or make efficient what you might otherwise need to invest in drainage attorneys or wetland technical consultants to help you through this process. With that, Amanda, I'm glad to take questions. I just want to know before I do that if a question gets very site specific, then I have to answer in terms of process rather than give you a yes or no legal advice from the webinar today. But I'm happy to answer any questions you have about WOTUS or about some of the other drainage related laws that were mentioned in my presentation.
Sure. Thanks, Kale. Let me just go through here and see if there's any questions that came up. Um, what type of water features on farmland are most likely to fall under federal jurisdiction?
That's a great question. Here's where I start when I get this question from a client or potential client with my analysis. We know that navigable waters, which are waters that you could traverse with a boat or a canoe, things that are streams, lakes, are permanent, obvious features. Those are the ones that are definitely covered by WOTUS. So we start there. And then I think we work our way upstream until we find our property where we're planning on doing our work. The relatively permanent, constant flowing tributaries, these are the features that have beds, banks, relatively permanent flow. Those are also going to be covered under the Clean Water Act. As we move upstream, now we're probably getting closer to our property where we're considering doing our project. And so from that tributary or navigable water, then we want to understand what other swales, streams, ditches flow into those tributaries or navigable waters. And are there wetlands on our property and do they abut any of those water features I just talked about? So I like to paint the picture that way. So we're starting with the downstream, obviously covered waters. And then as we work our way upstream, we're getting less and less likely in a scenario where federal WOTUS applies. As we talk about those tributaries and wetlands, if we move on a spectrum away from permanent water to what we call ephemeral or only occasional water, that means we're moving less likely towards federal jurisdiction. And when we talk about those wetlands on our field, as we move from abutting those covered waters to more isolated, farther away from those covered waters, we're also moving more towards the green light, less likely covered by federal jurisdiction. So the water features we're looking at are ditches, swales, waterways, watercourses, wetlands, ponds, sloughs. That's the type of terminology I hear doing work in North Dakota, where if I know that that water feature may be present on the property, then I'm thinking through, okay, do we have a Clean Water Act WOTUS consideration here?
Thanks, Kale. We have another question. I know you focused a lot on the Prairie Pothole region, but this is specifically asking as you go further west, a creek that drains into, example, the Missouri River, would it be covered by WOTUS?
Great question. So even though part of North Dakota on my map on my screen in the southwest corner is not part of the Prairie Pothole region, I want to be clear that the Clean Water Act still applies nationwide. And that means that all the parts of North Dakota, including southwest North Dakota. The Prairie Pothole map was just illustrating why that region of the state is an especially difficult one to apply these rules because the Prairie Pothole region is unique. But imagine a tributary in southwest North Dakota. This analysis would be true no matter what part of the state this creek or this tributary would be in. If that creek is connected to a downstream navigable water, like the Missouri River, the James River, the Cheyenne River, the Red River, then we want to understand and know whether or not that creek has relatively permanent flow, meaning throughout the year, is there water flowing in that creek, or is there water only flowing in that creek in a temporary reaction to like spring snowmelt or significant rainfall events? If it's the latter, then it's less likely to be WOTUS jurisdiction. And the reason is because it doesn't have that permanent, relatively permanent flow. If it is flowing year round, if it has a watershed that's big enough that it's pulling groundwater or can contribute and pull enough moisture out of the watershed that it's got water year round, not just when it's raining, not just when there's snow melt in the spring, then it's more likely to be federally jurisdictional. And the proposed rule issued in 2025 was trying to give some guidance as to what is relatively permanent flow and what is not. We're hoping to get even more clear guidance out of the final rule. But again, as I mentioned, that's going to be subject to litigation. The conservation groups are going to want to broaden what's relatively permanent. And of course, the regulated community is going to want to narrow it. So we can almost certainly expect that whatever guidance comes out of the final rule is going to be litigated by likely both sides. One side's going to say it's not narrow enough, and the other side is going to say it's too narrow.
Thanks, Kale. One question too. So if a producer, they have to follow both the federal WOTUS and like their state USDA, NRCS, plus get into the county and the state. What if they have land that is on a bordering, next to a bordering state, or even like, Canada, North Dakota, because that Prairie Pothole region covers a lot of that. What additional steps would they have to take? Would there be some boundaries across state lines too that they'd have to consider?
That's an excellent question. So for our neighbors who are on the border, whether it's federal, international border or state border, the Clean Water Act analysis for our state border neighbors is going to be the exact same. Those rules apply equally whether you're in North Dakota, South Dakota, Montana, or Minnesota. So that analysis is not going to be unique. The same is true for Swamp Buster, maybe with a slight asterisk, okay? The reason I say slight asterisk is because the Swamp Buster law, which is the one applied by USDA, NRCS, and FSA, that says you can't convert wetlands into cropland, the statute and text of the law and the regulations is the same no matter what state you are in. But the way in which it applies by the folks who work for the agency in your state differs slightly in each of the states and also differs slightly in the Prairie Pothole region from the non-Prairie Pothole region. So the state conservationists of the Prairie Pothole states, Minnesota, North Dakota, South Dakota, and Iowa, generally work together to apply the law similarly But even though that is their approach, my firm practices for drainage law for farmers and ranchers in all of those states. And so we know and we have experience that between North Dakota and South Dakota, for example, we see really big differences in how those same laws, even though it's the same text and words, get practically applied. But I think if you're planning a project and you're on the border of those states and you're worried, is something I'm doing in North Dakota going to trigger a unique law in a neighboring state? That's highly unlikely. The federal laws are the same laws no matter what state you're in, and the state laws that control drainage or water management are going to apply depending on the state where you're doing the work. Meaning the lateral effect for work on the southern border of North Dakota that impacts water in South Dakota is not likely to trigger North Dakota state law. That work is almost always going to be just exclusively regulated and controlled by North Dakota state law. Excellent question.
Well, thanks, Kale. I do not see any more questions coming in, and we are 5 minutes from 11 o'clock. So I want to thank you for taking your time and sharing your expertise. We really appreciate it. I am going to be following up with everybody with Kale's contact information in this presentation and the link if you want to rewatch it or share it with others. Again, thank you everybody for attending. Thank you, Kale. Be sure to join us next month on May 21st, where we will be talking about farm management in volatile times with NDSU extension expert Brian Parman to kind of talk about a lot of the farming difficulties and what kind of things we can do that. So again, thank you everyone for joining us today and hope you have a great day. Thanks. Bye. Well, thanks, Kayla. I really appreciate that.
Yes, you're welcome. Thanks for having me speak. It went a little faster than anticipated, so I hope that's okay.